It being 5:30, the House will now proceed to the consideration of private members' business as listed on today's order paper.
Affaires émanant des députés, private member.
Private members' business.
Second reading of Bill C-222, an act to amend the Expropriation Act, protection of private property, standing in the name of Mrs. Gallant.
Mrs. Gallant, seconded by Mr. Dreeshen, moves that Bill C-222, an act to amend the Expropriation Act, protection of private property, be now read a second time and referred to the Standing Committee on Government Operations and Estimates. Debate. The honourable member for Renfrew-Nipissing-Pembroke.
Madam Speaker, as Member of Parliament for Renfrew-Nipissing-Pembroke, I'm honoured to rise today and discuss my private member's Bill C-222, an act to amend the Expropriations Act with respect to the protection of private property. We acknowledge that Parliament is on Algonquin and Nishnabek territory, which is subject to an ongoing land claim process. I'm pleased to recognize the current movement to protect private property landowners' rights in Ontario started in my riding of Renfrew-Nipissing-Pembroke. I owe a debt of gratitude to the Renfrew County Private Landowners Association, the Renfrew Landowners Association, and the North Renfrew United Landowners chapters of the Ontario Landowners Association. Thank you for keeping me so well informed on issues of importance to landowners. There's been a disturbing trend in Canada toward what is referred to as regulatory, de facto, or constructive taking of private property. This happens when a government uses its statutory powers to regulate or restrict the property rights of an owner without acquiring the title of the land being adversely affected. The landowner feels the impact of the regulation as if the land has been expropriated. In the United States, the Fifth Amendment of the American Constitution protects private property rights. In Canada, a government acquisition of land without owner's consent is not subject to the Canadian Charter of Rights and Freedoms. Private property rights were excluded from the Canadian Constitution when it was repatriated in 1982. Bill C-222 is concerned with expropriations under federal jurisdiction. At all levels, governments require the power to expropriate private land. And expropriation laws set out a clear step-by-step process to resolve conflicts between private real property rights and the public's need for that same land. Peter Bowl and Rowan Summers in Expropriating Land, a Balancing Act write, and I quote, "Governments should want to limit expropriations and approach them carefully and sensitively so as not to be perceived as being unfair or abusive in any way. In the majority of cases that follow the common law, there are collaborative negotiations and offers on the part of the public authority behind the scenes in an expropriation. Accordingly, the strict formal steps in the process, including public hearing, are rarely needed. By far, most expropriations are satisfactory with resolutions on both sides when they are negotiated in good faith in the shadow of a legislative framework." End of quote. To quote Elizabeth Brubaker of Environment Probe, the court's long history of strictly construing statutes means that simple legislative changes, in particular, those more clearly defining public purpose, are effective in limited government discretion over expropriation. Bill C-222 is such a proposal. End of quote. In Canada, landowners' rights are found in the expropriation legislation. The government must follow the law as to what land may be expropriated and must observe procedures set out in the legislation. In Canada, the government can strictly regulate land, limiting its value and what a landowner can and cannot do it without triggering the procedures in the legislation. That's why it's time to modernize the Expropriation Act. I introduced Bill C-222 to provide some protections from the government taking people's property without notice, without a hearing, and without fair compensation. private property is defined as property over which the owner has exclusive and absolute rights. Private property is different from public property. Public property is defined as state or community-owned property, not restricted to any one individual's use or possession. The federal government has the authority to expropriate such property under the Act, specifically provincial lands. By explicitly limiting its scope to private property, the proposed exception in Bill C-222 would allow the federal government to expropriate public property, including provincial lands, for a public purpose that solely relates to the restoration of historical natural habitat or climate variability. Concerns about climate change must not be used as cover to confiscate value from private property. Agricultural producers in particular should not be required to subsidize someone else's environmentalism without compensation. The same must be said for all private property owners. It would appear that the recently signed Canada-US-Mexico Agreement on Trade addresses the issues raised by my private member's Bill C-222. As a result of signing this trade agreement, it would appear foreign investors in Canadian property are afforded more protection than Canadian owners of Canadian property. The source of this incoherence is Article 1110 of the North American Free Trade Agreement, or NAFTA, which has been carried over into CUSMA under Article 14.8 on expropriation and compensation. Article 14.8 in the new agreement provides, and I quote, 1, no party shall expropriate or nationalize a covered investment, either directly or indirectly, through measures equivalent to expropriation or nationalization expropriation, except A, for public purpose, B, in a non-discriminatory manner, C, on payment of prompt, adequate, and effective compensation in accordance with paragraphs 2, 3, and 4, and D, in accordance with due process of law. 2, compensation shall A, be paid without delay, B, be equivalent to the fair market value of the expropriated investment immediately before the expropriation took place, the date of expropriation, and C, not reflect any change in value occurring because the intended expropriation had become known earlier, and D, be fully realizable and freely transferable. 3, if the fair market value is denominated in a freely usable currency, the compensation paid shall be no less than the fair market value on the date of expropriation plus interest at a commercially reasonable rate for that currency accrued from the date of expropriation until the date of payment. 4, if the fair market value is denominated in a currency that is not freely usable, the compensation paid, converted to the currency of payment at the market rate of exchange prevailing on the date of payment, shall be no less than A, the fair market value on the date of expropriation, converted to a freely usable currency at the market rate of exchange prevailing on that date, plus B, interest at a commercially reasonable rate for that freely usable currency accrued from the date of expropriation until the date of payment. And 5, for greater certainty whether an action or series of actions by a party constitutes an expropriation shall be determined in accordance with paragraph 1 of this article and Annex 14-B. End of quote. Now, the language here was rolled over from the 1992 NAFTA, and it refers to the indirect nationalizing or expropriating of a measure as being tantamount to nationalization or expropriation. The language clearly exists to ensure that compensation will be owed for both de jure and de facto expropriation by the expropriating country. Now, the scope of Article 14.8 is indeed wide. Measure includes law, regulation, procedure, requirement, or practice, and the definition of investment is expansive. To quote James Beaton, is writing on expropriation without compensation, quote, "Moreover, there is no allowance, as there is in Canadian common law, for express statutory language to extinguish the right of compensation," end of quote. How the previous NAFTA Article 1110 has been treated in arbitration among the parties of NAFTA, Canada, and the United States and Mexico has, or at least should have, bearing on expropriation in Canada generally. This is particularly so given NAFTA's, now CUSMA's, constitution-like status as a document which cannot be amended without the consent of all signatories. Now, expropriation in NAFTA, now CUSMA, includes not only the open, deliberate and acknowledged takings of property, but also the covert or incidental interference with the use of property, which has the effect of depriving the owner in whole or insignificant part of the use or reasonably to be expected economic benefit of the property. With the ratification of CUSMA, where that will leave expropriation law and Canadian property rights in the future is uncertain. CUSMA is not only the only international agreement signed by Canada where foreigners are afforded more private property protections than in Canada. From the Lake Ontario St. Lawrence Plan 2014, signed by President-elect Joe Biden in 2016 when he was Obama's VP, and this government, protecting against extreme water levels, restoring wetlands, and preparing for climate change, quote, "The Lake Ontario St. Lawrence River study concluded that an estimated 25,000 privately owned riparian properties are located on Lake Ontario and the St. Lawrence River upstream of the Moses Saunders Dam. More than 3,000 shoreline property parcels are located below elevation 76.2 meters and could be at risk of flooding on Lake Ontario and the upper St. Lawrence River. The restoration of more natural water level regimes in Lake Ontario and the St. Lawrence River is not a traditional wetland restoration project, which typically includes harvesting and planting and physical transformations of the wetlands or cleanup of pollutants," end of quote. The federal government, in addition to being fully aware that Plan 2014 was intended to flood residential properties, has obligations in accordance with the Boundary Waters Treaty of 1909, Article 8. Quote, "Interests on either side of the international boundary which are injured by reason of construction, maintenance, and operation of the work shall be given suitable and adequate protection and indemnity as provided by the laws in Canada or the Constitution and laws in the United States, respectively," end of quote. While flood victims in the United States are being offered compensation for properties confiscated by flooding as a result of government policy, Canadian flood victims have yet to see recognition of their losses. The time has clearly come to give equal, if not more, protections in the law to Canadians than what is now given to foreigners in Canada. In a recent United Nations study, countries with stronger property rights are more economically advanced. It's time to modernize expropriation law in Canada to be consistent with international law. In conclusion, the ownership of private property is not constitutionally protected in Canada. The Crown can take private land for the public good. It is a general principle of expropriation law that the Crown must compensate landowners when it takes their land. In reality, this does not always occur when the expropriation occurs outside a legislative framework. So Bill C-222 would clarify that restoring natural habitat and addressing the consequences of climate variability do not constitute special circumstances. Bill C-222 recognizes that expropriation may be desired for these purposes, but that due process must be followed, and private landowners should not be forced to give up their land without notice, without a hearing, and without fair compensation. Flooded properties due to government policy should be treated like an expropriation. This would trigger the legal process for compensation contained in the Expropriation Act. Now, I welcome a vigorous discussion regarding Bill C-222. Thank you, Madam Speaker.
Questions et commentaires. L'honorable secrétaire.
The Honourable Parliamentary Secretary to the Minister of Public Services and Procurement.
She knows, however, that the policy of the Government of Canada is to always hold hearings. Hearings have always taken place in the context of expropriations. Willing buyer and willing seller is the policy of the Government of Canada. And expropriation, of course, is always a last resort, and I think those to whom she seeks to appeal should be well aware of this fact, that expropriation is always the last resort of the Government of Canada. However, I have a specific question for the member. She stated on her website that the bill seeks to amend the Expropriation Act to amend private property protections for Canadians, and that it would set out exceptions that seek to, quote, remove some uncertainty from the existing legislation as to whether owners must be compensated for certain types of de facto takings. To be clear, the bill would not accomplish this goal. Why does the member pretend that the bill accomplishes a goal that it does not?
The honourable member for Renfrew-Nipissing-Pembroke.
Thank you, Madam Speaker. So there are two types of expropriation, as the honourable member alluded to, de jure and de facto expropriation, and my private member's bill is focused on the first type. The private member's bill would clarify that restoring natural habitat and addressing the consequences of climate change do not constitute a special circumstance, and thus would be brought into through that specific identification into the legislative framework and be a basis upon which the affected landowners could take it to court.
Questions et commentaires. Oups. Désolé, c'est en...
Questions and comments? The Honourable Member for Abitibi-Témiscamingue. In fact, this is rather an odd bill, and according to us, is that we're just saying that denying climate change could be a bad thing. So C-222, the government will never be able to invoke the emergency appropriation regarding climate changes. Expropriation, it comes from the Latin expression to depossess someone, unlike in the United States, where ownership is not enshrined in the Constitution. Therefore, in Quebec, this is protected under the Civil Code. People are entitled to the enjoyment of their property. And owners cannot give up their property unless expropriation is done under by law and in exchange for an indemnity. Does the member understand the difference between the Civil Code applied in Quebec and the common law? Thank you.
Député de Renfrew-Nipissing.
Thank you. First of all, I would like to make sure that the honourable member interprets my legislation correctly. The bill, by clarifying that climate variability is not a special circumstance under which the government can declare an expropriation, it specifically puts into legislation and confirms that it exists. Secondly, with respect to Quebec, it's interesting that he mentions expropriation in Quebec, because I understand that in the city of Montreal, letters are going out to certain property owners asking them to sign away the title on their land. It just makes it sound like it's something business as usual. And if they sign this land or get tricked into signing these forms, they relinquish their title to this land. So it's a different type of expropriation, wherein, the government is not paying compensation to the landowner, but rather tricking the property owner into giving title to the municipality.
Very brief answer from the Honourable Member from Hamilton Centre. Question, rather.
Thank you very much. We heard the honourable member speak at length about property law and the dispossession of land, and I wanted to hopefully have her comment on the original expropriation by the Crown, which is that of the Crown dispossession of land from First Nations people, and in particular, the ongoing case that's happening today at the Haldimand Tract under the proclamation of 1784 from the Haudenosaunee people, and wondering if she might comment on the ongoing dispossession of land by the Crown of Indigenous peoples across these lands. She mentioned it, Madam Speaker, in her opening remarks.
A very brief answer from the member from Renfrew-Nipissing-Pembroke.
Okay, thank you, Madam Speaker. And in my opening remarks, I referred to the fact that there is still a comprehensive land claim going on the land where Parliament is situated. In terms of expropriation as it applies to First Nations, the Expropriation Act itself actually excludes matters dealing with First Nations, the land matters. So there are specific exclusions referring to those types of situations. But I thank the member for his interesting question.
Resuming debate, the Honourable Parliamentary Secretary to the Queen's Privy Council.
Yes, thank you, Madam Speaker. You know, I was interested actually in hearing what the member had to say about the bill, because when I first heard about it, I was a bit miffed in terms of what is it that the member opposite was trying to be able to accomplish. And I must honestly say, after listening to the member, I'm still not convinced in terms of what it is that the member is hoping to be able to accomplish. Because many of the things that she talks about, the question that comes to my mind is, where is this example? Where do we have the federal government in the last 50 years doing the type of thing in which the member is hoping to be able to get the government to stop doing? Is she anticipating that future conservative governments might change the way in which we have been doing things in the last 5 decades or so? I'm not perfectly clear. And then I'm thinking, Madam Speaker, you know, these opportunities that we get to be able to have a private member's bill or a motion debated is very rare, as I know the member opposite is aware. And when I look at the substance of the bill, and I listen very closely to the member, and I must say it's the first time I heard her make a presentation in kind of a lawyer format in the details, and still I didn't get the kind of clarification I was hoping to receive. You know, when I think of the issues of expropriating of properties, that there's always a willing buyer or a willing seller. That is what we have seen through Liberal administrations. When the member talks about, well, we want to mandate hearings, there is hearings that take place. There is a great deal of consultation that takes place. And she seems to be fixated in regards to, well, you know, this whole climate change. And I know there's many conservatives, many of her colleagues that are what we would classify as climate change deniers, that they don't recognize the reality of how the world is evolving in regards to climates. And she incorporates that into the bill, Madam Speaker. And she's, you know, talking about, you know, climate change and restoring to natural habitat. And these are issues that no doubt are there. But I don't see the connection in terms of what it is that the member is hoping to accomplish with this bill. Whether it's national governments, provincial governments, municipal governments, and others, Indigenous-related issues and property issues. These type of things take place on an ongoing basis, and generally speaking, Madam Speaker, it's usually for very admirable reasons that it takes place, and I'm wondering to what degree the concerns expressed by the member are somewhat misplaced. And I'm trying to figure out in terms of where there might be that national example in particular that has got the member so upset that she felt it was necessary to bring in legislation. I couldn't think of anything, and as the member saw, with the limitations of the number of questions she was being able to provide answers for, and maybe after the debate she can share with me or send me an email. She has my email address, and cite me, an example in the last 50 years where this bill would have actually been applied. And I think that would be very, very helpful. Madam Speaker, I look at the issue of, as a society, we continue to move forward, and one of the things that we have witnessed is huge investments in infrastructure. Even Stephen Harper at times recognized the value of infrastructure, where there was land that was designated, where we saw large patches of land that are taken into consideration in terms of building a highway. Or in this case, it was with the former administration when they looked at building Canada Way. And no doubt there would have been issues surrounding land. But you always find that there's a high sense of that willing buyer and willing seller. And there is discussions that take place. There are hearings that take place. I think of municipalities that have, in my own city, we have Plan Winnipeg, where you would have visionary people sitting around a table and talking about what they envision the city is going to look like many years from now. And I suspect whether it's people that sit around talking about that Plan Winnipeg, in which I'd like to provide some comment on, or it's the Capital Region, the Capital Commission, who does a fantastic job here in Ottawa, or other councillors, Madam Speaker. When we talk about the billions of dollars that this government has committed to building Canada's infrastructure, supporting our economy and our communities, recognizing the value of doing so, there is no doubt going to be opportunities where you will see different types of discussions that will take place, where you will witness individuals that will sell their land, and different levels of government will end up purchasing land in order to be able to accomplish, whether it's something both short-term or long-term. And I just don't see the area that the member seems to be so concerned about. When we talk about that natural habitat, well, natural habitat, there's been literally hundreds and thousands of acres in the prairies that have gone back to that natural habitat, Madam Speaker. And member might be surprised to know, but nothing has really changed in terms of legislation in order to be able to accommodate that. It's almost as if the member is trying to, get a fear out there that's just not there. And I don't quite understand why she would want to do that. Where it makes sense, and where you have that willingness to make it happen, why would someone oppose that? More and more society as a whole is recognizing that as different levels of government all have an important role to play when it comes to our environment. And it seems to me that that the member and possibly the Conservative Party needs to be more sensitive to the issues that our municipalities and our provincial jurisdictions, and even those progressive Conservative provincial jurisdictions, and some of the issues that they too have to be able to overcome, along with the federal government, as we, and I will concede, have a very ambitious plan when it comes to developing our economy, and we recognize the need to, when we talk about our economy, to also talk about issues such as our environment, they call it sustainable development, working with Indigenous people and leaders and other stakeholders, including provinces and city. There is no doubt opportunities well into the future so that we can actually have, that forward-thinking plans as to where Canada as a nation will be, 50 years from now, 20 years from now. I don't share the same concerns that the member opposite has, based in terms of what we have seen in the past. In fact, I suspect that if you were to have a generalization from the population as a whole, that you would see that there's wide spectrum of support for issues such as recognizing the reality of climate change, recognizing the importance of restoring natural habitat where we can. And I would encourage the member to send me some specific examples from the national level to my email account, and I can assure I will read them very, very carefully. Thank you, Madam Speaker.
L'honorable député de Beauport.
The honourable member for Beauport-Limoilou. Thank you, Madam Speaker. Tonight I'm speaking to you on behalf of the Bloc Québécois regarding Bill C-222, which amends the Expropriations Act. The very concept of expropriation is not new in human history, nor is it new in Canada. As early as antiquity, expropriation was used and it allowed the development of organized societies. In Quebec, the right of ownership is protected by Section 6 of the Charter of Human Rights and Freedoms, which states that everyone has the right to the peaceful enjoyment and free disposition of his or her property, except as provided by law. Quebec civil law, the droit civil, is derived from French law, which, since 1789, has recognized the right of the state to expropriate in the public interest under certain conditions. The Code Napoleon would later take up this principle, which was then taken up again by the Civil Code of Lower Canada and finally by Article 952 of the Code Civil of Quebec. In Canada, the first law on expropriation dates back to 1886. This was followed by the Expropriations Act of 1952, in force until 1970. This act contained no criteria for compensation and did not require the governor and council to explain the reasons for this or for any expropriation. This is unacceptable. These are pure hints of imperialism imposing its visions without regards for anyone. This disregard for the people was corrected with the 1985 law. 1985. Expropriation is not an action that is pleasant to experience, and I dare imagine pleasant to impose onto others. Mistakes have been made in the past. For example, expropriations made to create Forillon Park that caused significant trauma, expropriations that were done to create Mirabel that also caused significant trauma. With regards to the Quebec government, expropriations were made in the context of the closure of the villages of the Lower St. Lawrence and the Gaspé Peninsula in the 1960s. My grandmother, Cécile Gagnon-Vignola, worked, in fact, in operations in order to support the victims of expropriations. Here, we're not talking about expropriations without foundation. It is specifically about expropriations caused by natural disasters or by the need to protect the environment, especially most fragile areas of this country. The bill before us today does not deal with compensation procedures, but with the reasons that can be invoked for emergency expropriation. Two sections are amended in much the same way. Section 10 and 19 see a subsection added to limit the emergency expropriation powers of the governor and council. That have not been used, as far as I know in my limited knowledge, over the past number of years. These added subsections clarify that the Governor and Council will no longer have the right to order emergency expropriations in the very specific case of restoration of former natural habitats or climate variability. In other words, the Governor and Council may make emergency expropriations except in the case of environmental and climate change issues. Accepting such changes would be as irresponsible as saying that the environment is not important and that climate change has no impact, or worse, that it does not even exist. Some will say that it is not up to the government to decide where people should settle or resettle. In some cases, however, it is clear that governmental intervention is necessary. Human beings, being humans, and what they are, we sometimes only see our personal interests without a long-term vision, without an intergenerational vision. Now, it is high time to relearn to take care of our environment, the environment in which we live, and to do so not only for our own navel and our own interests, but also the interests and navels of people who will live after us. Just 1 second. I dropped my papers, unfortunately. Let me give you 2 examples of why the bill cannot be accepted. In 2019, due to record floods, the Sainte-Marthe-sur-le-Lac dike broke, resulting in the emergency evacuation of 6,000 of the municipality's 18,000 residents. That's 800 buildings and housing units. It should be noted that the municipality was largely built in a flood zone protected by said dike. As humans, we believe that we are capable of beating Mother Nature, the strength of Mother Nature. It was necessary to act quickly to raise the dike, limiting the view of the lake from certain properties and, as a result, diminishing the value of these homes. Had Bill C-222 existed in Quebec in 2019, raising the dike would not have been possible. As a result, citizens would have to see their municipality flooded year after year after year for the simple reason that these same people, these same citizens, would prefer to see the lake rather than be protected from flooding. What would this have meant? Year after year, these people would have been flooded. Year after year, the government would have had to deploy significant efforts to remove people from flood zones, to house them, to compensate them, etc., etc., etc. So this is taxpayer money spent every single year. It's not only the owner that has an issue, it's all Canadians that pay taxes because of this kind of event. There's also insurance costs. Every time, or nearly every time there's a natural disaster, prices increase, premiums go up. Not only the insurance of people who are affected, but everyone's insurance is increased. So the fact that we're trying to protect personal property, which is an important right, also has an impact on all Canadians. It is therefore important to give the government the right to act in the interest of all Canadians rather than just in the interest of 1 or 2 people. The government must be able to make emergency decisions. If, since the 1960s, we had thought beyond our own individualism, no one would have settled in a flood zone. It would have been banned from the very beginning. So natural disasters like in Sainte-Marthe-sur-le-Lac, the big storm in the lower St. Lawrence in December 2015, if memory serves, where houses and garages were simply swept away by the river because they were built too close to the river, this would not have happened. It would have been banned, building in these areas. Taking care of our environment is taking care of our economy, of our food. We must go beyond our own personal desires. We have to think about future generations. In this bill, there is an indirect aspect that states that the Governor and Council could decide that someone cannot build in a specific area. This is an indirect expropriation, and I think this is also important to preserve this possibility. For example, in marshland, a constructor sees a marsh, I'm going to drain it, I'm going to build, it's going to be amazing, fantastic, but if you don't understand the underlying geomorphology of the place, if you don't understand how marshes work, then even by draining the swamp, foundations sink, houses split, and people then turn towards the builder, towards government for compensation. Once again, Canadians will be paying the bill. It's not just a question of environmental affairs, it's a question of equity and fairness for all Canadians. We shouldn't have to pay for the mistakes of one or two individuals that make a personal choice detrimental to the rest of Canadians. Thank you, Madam Speaker.
The honourable member for New Westminster Burnaby.
Thank you very much, Madam Speaker. I'm rising to speak on Bill C-222. And the summary of the document for the bill provides for the following: that this enactment amends the Expropriation Act to provide that the power of the Governor and Council to waive the requirement for a public hearing in respect of an objection to the intended expropriation of an interest in land or a movable real estate might not be exercised in certain circumstances. Now, Madam Speaker, further on in the bill, the Expropriation Act, it cites the two examples of where that right to waive the requirement for the public hearing may not be exercised. It is in restoring historical natural habitats or addressing directly or indirectly climate variability. That, in the essence, is the bill that is before us this evening, Madam Speaker. And I have enormous respect for the member from Renfrew-Nipissing-Pembroke. I disagree with her vehemently on many issues, but certainly respect her hard work in the House of Commons and that she is one of the deans of the Conservative caucus. That being said, I will not be supporting this bill. Now, Madam Speaker, I'm going to cite the two reasons that are given in the Expropriation Act for why there should be an inability of the Governor and Council to waive the public hearing requirement. The first, as I mentioned earlier, is the restoring of historical natural habitats. And Madam Speaker, the origin of this, of course, is the devastating floods that took place in 2017 and 2019 in Renfrew County. And Madam Speaker, I think all of our sympathy and thoughts are with the many, many people in that region that suffered losses during that time. Hundreds of homes were damaged, many were destroyed. And so the 2017 and 2019 floods were absolutely devastating for the region. And that is why this legislation purports to waive the requirements for waive the Governor and Council's ability to override public consultations. But when we look at the reasons behind the flooding, often cited as a result of IGC actions, we can actually see that there's a difference between what is being promoted by the bill and what actually happened on the ground. Now, Doug McNeil, who wrote in his independent review of the 2019 flood events in Ontario, this was commissioned by a Conservative government, Madam Speaker, so a Conservative member, of course, would agree, I think, with the recommendations and the conclusions in that regard. Doug McNeil said, and I quote, "Some believe that the IGC's operation has a negative impact on Ottawa River flooding." And he goes on to cite in the report that was filed with the Conservative government that the IGC actions had absolutely no bearing on flows of the Ottawa River. There is indeed, though, things that had an impact on those devastating floods. And they're cited in the report as climate change and impacts of a changing climate. Those are cited repeatedly, Madam Speaker, in McNeil's reports. So the first item that is cited in the Expropriation Act simply doesn't hold water, Madam Speaker, if you'll excuse a pun in that sense. That the reality is the IGC very clearly from the report of the Conservative government did not have an impact on the devastating floods that impacted so many people in Renfrew County and in other areas. But, Madam Speaker, there is a second item that is cited in the bill, and that is climate variability. Now, climate variability, Madam Speaker, as you're well aware, is not the same as the climate change crisis and the climate emergency that this House has already ruled on and that we are currently in. And I'll come back to that in just a second, Madam Speaker. The member, who I respect but who I disagree with vehemently, has stated that in reports that she has actually filed with her local riding, that there are alarmist claims about man-made global warming. Now, Madam Speaker, these are facts. These are scientific facts about the impacts of climate change and the impacts of the climate emergency. And the good people of Renfrew County are not immune from the climate emergency that we're seeing around the planet. As I cited earlier, Madam Speaker, we saw 2 devastating floods that impacted hundreds of homes and hundreds of homeowners in the area around Renfrew County, in those devastating floods of 2017 and 2019. Now, Madam Speaker, in British Columbia, I can tell you also that 2 of the last 4 summer seasons, we have not seen literally the sky as the impact of forest fires due to climate change have completely shrouded the lower mainland of British Columbia. Now, Madam Speaker, when I was a child, I can remember incredibly blue skies throughout the summer in the lower mainland of BC. This has been impacted by climate change. And the reality is, Madam Speaker, climate change has not just had an impact on the quality of life, the people of Renfrew County or the people of British Columbia, but we have seen around the world the devastating impacts of climate change. These are undeniable. We can't talk about climate variability. We can't say that, as the member has said, alarmist claims about man-made global warming. The climate emergency is upon us, Madam Speaker. And people around the world are living with it, and people around the world are saying that governments need to step up now. Step up to stop the climate emergency. Step up and make that transition to clean energy, Madam Speaker. And so the impacts of 2 of the last 4 flood seasons in Renfrew County are very similar to impacts on 2 of the last 4 summers in the lower mainland of British Columbia, and many other regions of Canada can cite similar impacts. This summer, we saw the western United States ablaze, Madam Speaker, and the impact of that smoke was even felt in southern British Columbia, as the many, many forest fires that were ravaging the western United States because of the impacts of climate change blew that smoke right into the Salish Sea and the lower mainland and southern Vancouver Island as well. So we know that those impacts are being felt. We know that the economic impacts, Madam Speaker, are also being felt increasingly. The cost of the Canadian economy this year will be $5 billion. We know that that amount is going to increase each and every year. Within a couple of decades, Madam Speaker, projections say that the cost of the Canadian economy will be $50 billion a year, the cost of climate change. So we have to take action, Madam Speaker, and I would suggest it's not by adopting Bill C-222 that talks about climate variability, but it is actually taking action to help people in Renfrew County and to help people right across Canada and around the world. That means we have to stop the incredible supports that are given to the oil and gas sector. $12 billion, as you know, Madam Speaker. Canada now is in a very sad race with Saudi Arabia in terms of the egregious amounts of supports that are given to oil and gas CEOs. And yet, Madam Speaker, we've not seen any investments made for energy workers, and I'm part of the energy sector, came out of the Shelburne oil refinery in Burnaby, British Columbia, so I've worked in the oil and gas sector, and yet there have been no provisions made, either by the Conservative government in Alberta and Saskatchewan or the federal government, to actually transition energy workers from the fossil fuels that are helping to provoke climate change to clean energy that would help to address the climate emergency and bring down the egregious levels of greenhouse gas emissions that we are seeing that are literally burning our planet, Madam Speaker. Those are the kinds of actions. That would be the kind of bill that I would certainly be willing to support, Madam Speaker, that would actually tackle the efforts of the many people are undertaking around the world to address the climate emergency. And so that is what I would be prepared to support, Madam Speaker. That would be something that would certainly address the concerns of the good people, the very good people of Renfrew County. I know the area well, and I know that they as well understand that there is a climate emergency and that our governments, both provincial and federal, have to take action. So, Madam Speaker, I'll be voting against Bill C-222. I believe that we need to be taking action on the climate emergency, and I hope that we will see further private members' legislation that will actually address something that the government, for the moment, seems unwilling to address. Thank you, Madam Speaker.
The honourable member for Red Deer Mountain View.
Well, thank you very much, Madam Speaker. And just to comment on the last speaker, I think really there is an opportunity, if he was to come to Alberta and Saskatchewan, to look at the great work that is being done there to combat greenhouse gases and all of other things that are happening within the industry. I think that would be helpful, and perhaps then the rhetoric would be just a little bit more logical. Madam Speaker, my family fled oppression in disputed area of Schleswig-Holstein, Germany in 1870 to come to America, a land healing after having just gone through a devastating civil war. Because of issues arising from one of the Oklahoma rides, two of the sons ventured north to Canada's Northwest Territories to farm in which was eventually to become Alberta. So as you can imagine, Madam Speaker, the issue of property rights and freedom runs deep in my family. Other pioneers in our central Alberta community arrived from the far reaches of the world. Many of these new neighbors were from war-torn communist countries, and they cherished the fact that once and for all they could breathe freely knowing that their hard work, their commitment to their family and their community would be respected, and that their ownership of property would be honored. Each of us, all 338 members of Parliament, need to remember the dedication and sacrifice that those that came before us showed and endured. Sadly, there are still some situations where governments have extraordinary powers that are easily abused. This is why I'm so honored to speak to Bill C-222, an act to amend the Expropriation Act, protection of private property. And I want to congratulate the honourable member for Renfrew-Nipissing-Pembroke for bringing this important legislation forward, and I know that she too is a passionate advocate for the defence of property rights in Canada. We play several roles as elected members. I can't think of many functions that are more important than working to safeguard the property rights of our constituents. Property rights form one of the most important cornerstones of our society and of our economy. There are some among us who like to equate the notion of rights with individual liberties or freedoms to do whatever we want. But property rights are not only paramount as part of our tradition, but are essentially the foundation for all other rights as well. We often like to equate the notion of free speech with the ability to say whatever we want, which is true to an extent. But as we know, there are limits to this axiom. The possibility of severe harm because of hateful views is but one example. But this right to free speech doesn't apply when you're trespassing on someone else's property. There must remain a fundamental degree of respect for the owner of that property. And we've seen situations like that in the past. In the same vein, the right to freely associate is not the right to associate anywhere we want to. We don't have the right to freely associate on private property. We can do so in a public space or in a space that we own. The bottom line is that there generally are no such individual rights or liberties beyond the property rights that a person may have. This is why I say that property rights are so vital. It's certainly one reason why standing up for the property rights of our constituents is such an important part of our jobs. Madam Speaker, in my riding of Red Deer Mountain View, we know about the value of property and the importance of property rights. Many of my constituents are farmers or ranchers. They put food on the table for their own families, as well as for millions of families across Canada and around the globe. In many cases, they grew up on a farm, as did I. They know the value of a hard day's work. They understand the importance of taking care of what they own, of living frugally and responsibly, of saving hard-earned money to make a down payment on a house, on a new farm, building or to expand a herd or the size of their farming operation. And the same is true for our local business people. They work hard for years so that they can save enough money to expand their business, to look for new clients, to hire more workers to keep their businesses growing, and to hopefully have something left for their family in retirement. So as elected members, we must stand up for and proudly say that we will help protect the property and the property rights of our constituents. This is why the bill that we are addressing here today has such significance. Madam Speaker, we've always heard that property rights are not protected under Canada's Charter of Rights and Freedoms. This is different from other countries such as the US, where property rights are constitutionally protected. Under the Fifth Amendment of the American Constitution, no private property may be taken for public use without just compensation and without the due process of law. In contrast, what we're seeing here in Canada is a disturbing trend towards what is referred to as regulatory, de facto, or constructive taking of private property. This happens when governments use its statutory powers to regulate or restrict the property rights of an owner without acquiring title to the land that's being adversely affected. The landowner feels the impact of the regulations as if the land had been expropriated. Put another way, the government can strictly regulate land, limiting its value and what a landowner can do with it without triggering procedures in the legislation. A de facto or regulatory taking means the property owner is normally not entitled to compensation. What's worse, Madam Speaker, is that we've seen many examples in jurisdictions across Canada where the government has actually misled the owner and the public about the intended use of a property in order to circumvent the need to pay a landowner compensation, choosing to follow the regulatory taking route rather than following the rules under federal or provincial expropriation laws. If a government changes the designation of property to avoid compensation under expropriation statutes, and then subsequently redefines the designation for future use, this avoiding of higher compensation is an abuse of power. Madam Speaker, Bill C-222 seeks to remedy this type of situation and remove uncertainty from the existing legislation as to whether owners must be compensated for certain types of takings. The goal is to protect private property by ensuring that governments follow the rules of due process. Bill C-222 seeks to remove uncertainty from the existing legislation as to whether owners must be compensated for certain types of so-called regulatory takings. As I mentioned at the beginning of my remarks, one of the most important functions that we perform as elected members of this place is to protect the property rights of our constituents. I know that I want to leave a legacy for future Canadians where property rights are protected. We've come too far as a free and caring nation. We've been the beacon of hope for immigrants from all over the globe. We must continue to ensure